With this hopeful note, we can begin our last roundtable to have a little time to reflect on what we have seen or what was left unsaid. And I think I wanted to maybe begin with a very short thought that one of my aims in this conference was to overcome compartmentalization. That a lot of the discussions here are compartmentalized to different departments, different kinds of, so there is the criminal law and there is the civil law, there are the artists and there are the historians, there are the genocidals and different kinds of genocide, different kinds of people, and no, I'm not, yeah, sorry. Genocide studies. Yeah. I meant genocide studies. So I wanted to show you some of the commonalities that can that this kind of conversation allows us to think together. So we just heard about the Sakakini library, and we began our conference with Wouter, who also wrote about his library and having to leave his library and what does it mean. So all of a sudden you begin to see commonalities, differences. What are people doing about it? We saw also Jennifer talking about transitional justice museums, but we had here Shlomit from the Israel Museum thinking of how a museum that was built as part of the understanding of cultural reconstruction and still has to deal with its own legacy of not doing enough research and finding and how do you restitute art. So I think that these kind of connections, and I was really excited to find out that the Polish art historian Estreicher was in contact with the head of the Jewish Historical Commission, discussing to whom does this culture belong, how do we restitute it. So I think these kind of connections are important for us, and of course we have here the Western understanding of private property, and the collectivist understanding of East European dealing with this. Very different approaches to the same questions, and I think we have to have a round table and not to think that this is the only approach that works, but to hear about different approaches, and of course we have here our Canadian approaches. So I think it's time to reflect about how do we benefit from it, not only about the dangers of comparisons, but also of what we gain from this kind of
Well, after the past 2 days, and especially after this afternoon, it's really incredible to try to just reflect a little bit. But I guess Alex and I were talking about how this series of conferences kind of came to be. And I read the Macron report, and in Canada we have a lot of issues, as we discussed, to do with our Indigenous populations. We are all, I am a settler, Alex is probably a settler, Jennifer's a settler. In Canada we've come to understand ourselves as settlers probably only in the past 10 years. No one, I don't think any would have, we never would have called ourselves settlers 20 years ago. And so Canada's had this process, but also we look around the world a lot. So I was interested in the Macron report, and I wrote a little editorial about it that ended up in a newspaper, and then Alex, who does this fantastic work on art and law in London, wrote to me and said, maybe we should think about doing something about Canada and the colonial issues. And I said, I have a friend, Leora. And that's kind of how all of this has come to be. But I mean, there are so many particular things that one could reflect on, but I guess as just thinking about what I don't at all, there are many things I don't have resolved, but the overarching puzzle that I think will preoccupy me is what the relationship is between individual, healing isn't the right word, but restoration, efforts to correct individual harms, even on a mass scale, and the more collective or global, not global, but the more collective enterprise, and what the connection between those two things is. It's something that kept coming up here. I think I have always, I think that people tend to think, at least in my world and often in transitional justice and in some of these areas, they either feel very strongly about one or very strongly about the other. And, the sense I have in listening to this dialogue, I really felt this strongly, is that they both need to figure out ways, I think, to work together. I think that just saying, as has happened very much in Canada, forget about trying to compensate Indigenous Canadians for what they lost. We can never give them back what they lost. It's just time to move on, look at the future, let's get the past behind us. That doesn't work, but neither does a gaze on nothing but the past. And so I think, the way that some of the conversations we've had have brought together both discussions about restitution and reparations, but also how do those fit with more transitional justice kinds of tools that I think at their heart are about changing something much more widespread, a mentality, a belief, a culture. Those two things, I think, is the way they work together in some ways that I found some of the most interesting themes today. So just a few thoughts. Alex, do you want this? You might just be able to talk.
Yeah, I might just speak. One thing I wanted to reflect on, because we are in the School of Law, just the different legal processes for dealing with some of the claims that we've talked about. And I guess what I have in mind are the ways in which the law has dealt with art that was taken during the Holocaust period. And wondering whether we can apply the lessons from that experience, let's say from the Washington Conference to today, to other areas, and whether it fits or whether it doesn't fit. And I think we're in the process. I think we've done some of that work over the last couple of days, and I think there's more work to be done, obviously. One of the things that has always fascinated me about the way the law deals with those, let's say, historical claims, is that it can either offer a legal recourse or sometimes a political recourse. The comparison I'm thinking about is the way the American courts have generally been more open to claims involving facts that might have occurred a generation, 2 generations ago. And in a way it's cultural, because I think it's fair to say our American friends are generally more litigious. American courts tend to have fairly broad jurisdictions, so they can hear cases that involve facts that might not be American. The Maria Altman case, I think, is a good example of that the courts were open to hear that kind of claim, even though the facts in the case involved something that happened 70 years earlier in a different country. And so the legal route, the purely legal route, the private law route, in a sense, is more available to claimants in the United States in that jurisdiction. If we compare that to different European jurisdictions, by the simple fact that most European countries have very different conceptions of limitation periods and jurisdiction. It meant that the strictly legal route, the private law route going through in, say, France or the UK, which I'm better, was just a non-starter. And so there had to be a political solution following the Washington Conference principles. So you had the UK, France, Germany, Austria, the Netherlands introducing these restitution committees, which have been operating over a good part of the last 20 years. And those are, they're interesting to study, and thank you, Matthias, for that analysis of the way, on one particular issue, how the different committees have responded to that. Because they operate a bit like administrative committees, but they're also advisory bodies, so it's ultimately the decision is going to be made by a minister or secretary of state or some political agent. And so to see that compared to the American approach, which is more about title and legal rights and whether you have persisting title, or in the Portrait of Wally case, which is from 10, 15 years ago, which we talked about, that was about whether it could still be considered stolen property. I mean, in many jurisdictions, something that happened that long ago would no longer be considered stolen property because of the expiry of title. But in the U.S., because of those very particular legal rules, you had that claim going through the courts. And as we heard, that particular issue was what inspired, or partly inspired, I think, a lot of what happened in Washington, right? Because it was right around that period. And so I sometimes wonder if within the kind of very technical black letter law U.S. approach, the private law approach, which often falls on questions of limitations, questions of jurisdiction, sovereign immunity, as Nico was telling us about, there's a kind of morality that comes into those decisions, even though on their face they look like very technical points about limitation. But when you read between the lines, you get that morality. I think it comes into play in some of the more recent cases under the Holocaust Expropriated Art Recovery Act, which we mentioned over the course of the last 2 days. So within the strictly legal, you could say technical approach with limitation periods, etc., you get that morality creeping in. And then in the 5 European jurisdictions that have the restitution committees, which in a sense are enabled to consider moral claims, like the UK Spoliation Advisory Panel, they're not to look so much at title and legal issues and legal rights, but to consider the moral strength of the claim. Sometimes those claims, even though it's about ethics and morality, they still have to fall back on things like, can you demonstrate a title? Can you demonstrate ownership? What kind of evidence do you have? So there's a mix on both sides. So it almost seems like whichever approach, whether it's a strictly private law approach or a more administrative political approach, they end up sharing interesting things that you wouldn't expect initially. Now, I don't know which of the two is the right approach. And then, of course, we have other countries that have chosen neither, in a sense, that we know which examples I have in mind. But I think in these issues, when we're dealing with historical wrongs, things that happened many years ago, sometimes in different jurisdictions, we have to obviously reach beyond the law into that area of ethics and morality, and to try to understand how that can influence an outcome, I think is an ongoing project. So that's what.
We'll have comments and thoughts now. Just one thought that I want to, one worry that I have with the panels, the restitution panels that the European, the problem of going outside the law is that it creates a particular solution to a particular problem, which is these panels about the Holocaust. So, and while when we take it to ordinary courts, there is this chance of other groups to come there and to claim, hey, what about the Armenian? What about the Sudanese? What about? So there is this claim of law for universality that doesn't appear when we really try to solve something very particular, because it cannot be very legalistic, but then we solve it only for this group, and not the other. So I want to put it on the table that there is this virtue of law that doesn't or make it very difficult for you to say, oh, this is only about the Holocaust, but not about all the rest, while the Washington principle moves us towards a very particular solution to a very particular historical issue. So I just wanted to put it on the table out on the one side.
First of all, I would like to thank the co-organizers for a great conference. I enjoyed it immensely. I am living with the Holocaust restitution for the past 20 years, and in 2 days I got new insights which will make me think and will invigorate my work to a great extent. So first of all, thank you. Now I would like to suggest or to share one insight. The Holocaust restitution process fluctuates. The big picture, I mean. It goes up, it goes down. At this moment in time, it is down. Nothing is happening substantial, except of art. It's the only area that is bubbling. Things are happening. There are conferences, there are new papers, there are new cases, there are new thoughts of what next, and so on. Now, the issue of art is very important, in my opinion, for Holocaust remembrance. And as Holocaust denial is increasing in the world, then Holocaust remembrance becomes much more important. It is very important for Holocaust remembrance because of the big number of pieces of art, of all the pieces of different areas. The number of pieces in art is the biggest. It's spread all over the world. It's accessible and it's easy to grasp. Easier than to grasp 6 million dead. I mean, how can you explain to a child or a youngster 6 million? What do you mean 6 million? So I would like to suggest a thought that some kind of common responsibility, which means that each one of us in their own area, their own compartment, if we would think also about what next. I mean, Matthias concentrated on it. That was his presentation, what next. I think that if each one of us will take the responsibility, and us as a group, of thinking what next, it will enhance the Holocaust restitution process, especially in a time when it's the only thing that is bubbling. Thank you.
I'm sorry. I'm also since almost 20 years involved in that, but being an independent person and looking what's going on in Europe and in Poland, or in Poland it's not going anyhow. I used to join quite a lot of conferences and workshops and so on, and this is not a cheap compliment. This is one of the most interesting meetings which I really joined. And the reason for that is that, let's say, this is on the level when you can compare, and where we can compare and talk without emotion about very different experiences, but of, let's say, wrongs of the history or of the present time, and then to look for the surface or just to the level when we can discuss the possible solutions, whether they are, even if they are not to be found. It is simply important to put it on this level. And this is the first conference, because usually when I'm just in the conference, of course, devoted to the confiscated art and libraries and, let's say, the Holocaust problems, this is always, it is a kind of ritual. It is a kind of ritual. And here, this is not the ritual. And even that especially here, I just told the Palestinian friend that especially that in Israel, one invites on the same level, not as a patron, but on the same level and higher than the, let's say, the Holocaust. the question also of Palestinians, which is the present want and the present catastrophe in one way. And then let's say we're talking about colonial, and this is something absolutely unusual. So thank you for all the organizers, really this is the great thing. And when, I'm not joking, I'm not the person who used to say compliments. And no, joking, I love to joke, I like to joke. But, and this, let's say, the next 2 chapters, one sees this is really the dialogue. And I mean, for example, that one can learn from each other. I mean, on the level of the restitution. That's what I said, that, for example, your friend was talking about that he doesn't want to have patrons. But he's talking about oral history. This is Spielberg. This is Spielberg, so we can learn from each other. So this is also unbelievably important. So thanks a lot. The second thing, just about archives, yes. This is a long run. This is, you were talking about military archives here, and it happened that I do not have the possibility to study in archives of the museums in Herbert. So they are closed. They are closed for people from outside, even being a specialist. So this is a long run. And this is not only the question of Eastern Europe. This happens also in Germany. You probably know it. Not each museum opens its records. And of course that, let's say, the inventories, they are also closed. And then one is in one way, as I used to say, half empty, half full glass. And this is constant the case. So I suppose that we have a long run, but this is also my experience. Thanks this involvement, and that one wins more and more people. This is also very important. And we really just make the history present. That's what you were talking about. We were talking just, for me, culture and cultural goods, they are really symbolic goods. Now when survivors die, this is the possibility, also because of the strength of the symbolic goods. And it doesn't have to be, let's say, masterpieces which cost enormous amount of money at the auction houses. This is not important. I have to tell you, I read, for example, the testimony of an unknown rabbi from Krakow, from the very small synagogue. Not the biggest one, not really the small synagogue. I could not believe he made from memory inventory of 1,200 books, which he lost, and he did it just in Hebrew from the first, and I understood reading this testimony that this was his love, this was the same as it was unbelievable. So if you compare such things, Benjamin, this Palestinian man, and let's say my rabbi from Krakow, that you that is open, that one has to understand what's going on. So we have, I don't know whether we have responsibility. We simply have to fight. For good reason.
We have very short time because we have taxis waiting for us. But I do want to let everyone say, but let's be brief. Yes, Eyal.
I was just thinking, watching the presentation of the Palestinian library and the letter, the passion for books, the desire to get it back, that it really corresponds with my presentation where I presented a letter of a Holocaust victim to her grandchildren, and it really, in my opinion, parallel. And just another thought that I had, what's common for many of the cases presented here is the accountability of the museums or the archives, or the unaccountability for the wrongs or for the good things which they are doing. So in a way, a museum or an archive can deny access or can deny restitution, and it does not get any penalty, I mean moral penalty, from the public for doing so. And I think, in my opinion, this is what's common for the cases we have seen, and one has to think how to confront it.
think one of the ways is to develop alternative procedures or alternative methods while working with institutional archive. I'm working with archive, but maybe also with museum and other institutions that block, the knowledge or conceal the knowledge. I know that I developed like alternative method because the path was very, very difficult and they didn't open anything. It looked like it was very quick. No, it's 20 years of traveling and they didn't want to open, and because I developed alternative methods, which I write about them, I succeeded in opening the material and making the knowledge about the looting. Nobody knew about the looting before I did this. Me and Abit Gish that wrote about the libraries, and I did about the visual. But it was not open, and you need to be creative, to develop unconventional, way of working in order to achieve the knowledge and to expose it. So this is one way maybe to deal with this aspect, to think outside, the box while dealing with such
in the case of archive.
I just wanted to mention that one of the themes that we'll explore in Toronto is the museums that are actually collaborating with communities, both supporting repatriation but also ceremonies, and so there are some really good examples of museums also being partners in change, which is hopeful.
We have two more, and
I will try to keep this short. As I think about the future, one situation that really weighs heavily on my mind because I've worked with this population so much is the Sudanese, which I mentioned very briefly yesterday. But the restitution context is so complex because for those people, so much of their wealth and property is in things like livestock that once gone cannot be gotten back. And so the US model of restitution clearly is not going to work for a group of people like that. That's a major challenge. In addition to the documentation issue when you're talking about real property, but then there's the personal property, the goods and chattels. What do you do about that? I think another significant problem that I think about is the long lag time that is likely to be the case before there could possibly be any serious conversation about restitution or restoration or reparations. Still there are so many people, entire families that just live in the refugee camps. They've been there 20 years and they're likely to be there, well, now that Bashir is gone, which is a sort of shocking development, nobody expected it really. Maybe it won't be another 20 years actually, but still, the time I think when restitution is most important is immediately after the conflict, because if people's property is gone, then they have no ability to rebuild their lives. It's very, very difficult without anything left. The refugees that came to the United States came literally with the clothes on their backs. And with no resources to start over, it's extremely difficult, and yet the time is going to be long still before there could be any possibility. So these are some things that...
Very, very short, because we all have to walk again.
Because I think that Jennifer papers really open a completely new dimension, not really like approach in this conference. So because this new museum of memory. So you mentioned Chile, so I remember the conference by Icon on Memoria y Justicia on Santo Domingo, looking how all these reconciliation committees deal with this new museum, how they cooperate. And if we think about also from the legal point of view, when we look on the issue of reparations and for the human rights violations, all these reparations, especially in the Inter-American system, the commemoration, so apart from the restitution of land, also the members of memory, it's really important. But there is only one important twist, but also looking at the new definition of icon, the recent in Kyoto, no? So is the polyphonic and so on and so forth. Now here, who is in charge of such places? No? So we know, like in Osaka, they removed now the Japanese atrocities. In Poland, we've got like attack on our museums, no? So this is a very important but also difficult. And in Toronto, it will be like part of the discussion.
Yes, absolutely.
Thank you, everyone.
Thank
We
you
will
all.
just
Thank
continue the